Hello, my name is Chuck Segelbaum, and today we're going to be discussing protecting artificial intelligence inventions. Your presenters today are listed on this screen. I'm listed here on the top here, Charles D. Segelbaum. I'm registered with the United States Patent and Trademark Office, and I've been here at the Fredrikson and Byron firm for a little over 20 years. I have a background in electrical engineering, and I provide a lot of assistance to my clients in trying to protect various aspects of their software, including artificial intelligence-related inventions.
Hello, my name is Michael Ginsburg. I am also a registered patent attorney with the U.S. Patent and Trademark Office. I've been with Fredrikson for about a year and a half, and before that, I was at a patent boutique here in Minneapolis. Prior to becoming an attorney, I was a software engineer for 8.5 years, mostly in research and development, and I hold bachelor's and master's degrees in computer science. I help my clients protect their software-based inventions, and I also do work with export controls and other aspects of law that involve software, such as M&A and open source software.
So there are three main types of intellectual property when it comes to protecting inventions relating to artificial intelligence. There's copyright, patents, and trade secrets. And we're going to run through mostly patents and trade secrets, but it's worth just commenting briefly on copyrights. A copyright protects, as it says here, the original work, maybe some ornamentation, maybe a graphical user interface associated with any software that you have. But when it comes to artificial intelligence, it might be the words that you choose, the source code that you create, things of that sort. It is the expression of the idea of what you create, the expression meaning the words you choose, the layout that you have, and not the functionality. So somebody could reverse engineer something that you were doing without violating any copyright of yours, as long as they do not copy, for instance, the look of whatever it is in your design. A patent, I think many people are familiar with what a patent is. It protects the functionality. It's really the main area of protection that you're going to want to try and seek in protecting your artificial intelligence inventions. It's not just the expression idea of the words you choose. Instead, it's more so, what are the inventions? What are the technological features of it? There are also design patents which can protect, for instance, the look of your graphical user interface. And then finally, a trade secret. And trade secrets can be very powerful, especially if you cannot patent something and it's something that you're able to maintain as a trade secret. So we'll go through these with a little more depth as we run through here. First off, with respect to patents, there are three main requirements of any patent, and it doesn't matter if it's artificial intelligence or anything else. The first is whether or not this is patent-eligible subject matter, and we'll talk about that a little bit more in a moment. The second and third ideas are ones that maybe you're familiar with, the 35 U.S.C. 102 relating to novelty. And as you would expect, to protect and patent something, your invention has to be new. And then 35 U.S.C. 103, your invention cannot be merely an obvious modification of what already exists. And obviousness oftentimes it's a term of art, it's a legal term of art, but the way it's in practicality that it comes out is that a lot of times people will take two different inventions if they're trying to invalidate a patent, or if the examiner is examining your patent for patentability, and say, is it obvious to combine these two pre-existing ideas? Because when you combine them together and forms your invention, well, gee, that certainly seems to be obvious. And that's one of the main arguments that we have when we seek the patent. But today we're going to focus mostly on the first item here, patent-eligible subject matter, 35 U.S.C. 101. And the reason why we say that is that artificial intelligence-based inventions, at their core, are in many ways merely software improvements. And SCOTUS, which is short for Supreme Court of the United States, back in 2014, and then with some cases that have followed that, really has substantially narrowed the type of software inventions that are patent eligible. So we talked about that first test there, 35 U.S.C. 101. There's a famous case, well-known case in shorthand called Alice, another one called Mayo, and so on, in which the court has concluded that abstract ideas are not patent eligible. And the difficulty is trying to determine, well, what is an abstract idea and what is not. So we're going to try and flesh that out a little bit further for you.
So other types of patent-ineligible software inventions. If the invention simply performs well understood routine or conventional activities using a computer, or merely automates a previously human activity, those types of inventions by themselves will not be patent eligible. What we do know to be patent eligible based on the Supreme Court decisions and Federal Circuit decisions are software-based inventions that improve the functionality of computer-related technology. And that could be, for example, making the computer or other software more flexible to change or to interoperability with other software, making the computer perform faster, allowing the computer to use smaller or fewer resource requirements such as memory, things like that. Also, if the software executes on patentable hardware, that is hardware that is patentable by itself, then the software will also likely be patent eligible. So applying the patent eligibility guidelines to AI inventions, as with all inventions, whether they're AI-based or not, the invention has to be new and non-obvious. But what is arguably patentable artificial intelligence are, for example, specific techniques or processes for training a machine learning model, specific definitions of feature vectors that are used in the training of the machine learning model, or specific forms of output representing different AI determinations.
And I noticed there that you said specific each time, meaning it can't just be the broad statement of, you know, a machine learning model that is trainable or something of that sort. You have to get into the sometimes into the weeds a bit as to how it is that you are doing this better and different from what has been done before. Is that right, Michael?
That is correct. You can't just state a result of your invention. You have to recite how that invention does what it does.
And sometimes while doing so, you know, you're going to have to disclose maybe more than you want. And so we'll talk about that in the trade secret section here in a moment. So yes, as with all patent applications, artificial intelligence-based patent applications publish 18 months after the file. So the patent has not issued yet, but the application and what it is that you are seeking for to patent will be then available for the public to read. There is a small opt-out of this publication requirement, but it's seldom used, and you have to promise that you're only going to file this patent in the U.S. But of course, when this publishes, you have destroyed your ability to keep this as a trade secret. And so keep in mind that going after this as a patent is pretty much a concession and giving up of the idea that you may be able to maintain this as a trade secret. So when should you maybe patent this, and when should you maybe keep it as a trade secret? Well, as we've talked about before, obviously, if it's something that is more likely to be patent eligible, as Michael just described a moment ago, that those are things that are in favor of it. But that these are things that don't necessarily contain a secret sauce or something that you don't want published. Or if this is something in which investors or potential acquirers are going to look to see, do you have patents filed for your inventions? That may be a real good reason to pursue this. And of course, if you get a patent, as we state here, you may have control over this technology for less than 20 years, but that still can be a very valuable piece of intellectual property. So it comes down to, going back to the beginning of the slide, top of the slide here, if this executes on an inspectable device, could it be reverse engineered? If you can't maintain this as a trade secret because it might be reverse engineered, well, that may be another reason to maybe pursue a patent on this, because you're not going to be able to maintain it as a trade secret. And I think this slide talks somewhat of the exact opposites of what's stated previously. If it can't be reverse engineered, or if it does contain some secret sauce, or if you're not worried about having investors or potential acquirers, those are the reasons why you might want to try and maintain, your artificial intelligence-based invention as a trade secret. And in addition to that are some of the difficulties that we've talked about already, relating to patent eligibility of software-based and artificial intelligence-based inventions, such that if you're not going to be able to patent it, and if you're going to have to publish it if you pursue that patent, well, there may be a reason why you would not want to do all those items if it's not patentable, not want to take that chance and instead maintain it as a trade secret. So the takeaways that we have here are that artificial intelligence inventions, just like other inventions, must be new, non-obvious, and the key thing here is that they have to be patent eligible for these inventions to be patentable in the United States. That the patent eligibility requirements have tightened here, but artificial intelligence is still patentable. There are still plenty of patents being filed and some being issued. I shouldn't say all of them, because there have been challenges, but they're still very patentable if we follow some of the guidelines that we laid out ahead of time. The key is, of course, to seek assistance from a qualified patent attorney to help you determine, well, is this patentable? Should I pursue this? Or should I consider protecting it via trade secret? And obviously, we'd welcome an opportunity if you'd like to contact us. Our contact information is at the beginning of this particular slide deck. We thank you very much for your time. Appreciate it.